Okay, welcome everybody to week 7. We are going to be talking about hearings, conferences, and trials. Just a reminder, everybody, now that the session is being recorded, just to keep your mics muted and your videos off. So first, I'd like to just do our territorial acknowledgements. We would like to acknowledge that we are on the traditional, ancestral, and unceded territory of the Musqueam, Squamish, Tsleil-Waututh nations. A summary about AC Friends of Court. We are a nonprofit organization. We began in 2011 with our first legal forms workshop being held at the offices of the Access Justice Center. Our legal forms workshops have helped British Columbians access affordable legal help for a variety of areas of law. At present, approximately 45% of our clients are family law clients, and this family law school is one of the first of its kind in our province. Some acknowledgements: our family law school would not be possible without the generous contributions of the people that we have listed on our screen here. We had some lawyers, our executive director, and a couple people from the National Self-Represented Litigants Project as well. A quick acknowledgement that some of our work is adapted from resources originally developed by the Justice Education Society, National Self-Represented Litigants Project, and Legal Aid BC. A reminder to everybody that the AC Family Law School does not give legal advice. These sessions only provide you with legal information. And just as we've gone through our past sessions, a reminder between what legal advice and legal information is. Legal advice is answering a question or providing information that is specific and directly linked to someone's legal case. Legal information is answering a question or providing information that is more general and not specific or directly linked to someone's legal case. Some housekeeping to go over. All of our sessions are being recorded. If you haven't sent in your participation agreements, please make sure to do so. Please ensure that you mute your mic and remain muted and turn off your video. All questions should be entered into the chat box only, and we will do our question and answer session at the end of our session. Keep all details of your case private. Do not share anything specific about your cases. And then respect others when communicating. If you have any questions that we aren't able to address or just in general, you can send us an email to info@litigantschoolbc.com. A general reminder for people to please respect our speakers, our volunteers, staff, other registrants, as well as our presenters. About our guest speaker today, we have the Honorable Judge Nancy Phillips with us. She is from the Provincial Court of BC, and the areas that she usually handles is family, criminal, youth, small claims, and traffic court. So I'd like to welcome Nancy and thank you very much for joining us. Our last one that I'll just go over briefly is our objectives for today's session, and then I'll pass it over to Nancy. So we basically are going to go over preparing for hearings and some of the court etiquette, family management conferences, family settlement conferences, trial preparation conferences, understand what you'll be required of on the day of trial, making accommodation requests or requesting an interpreter, opening and closing statements, the role of witnesses, and then our question and answers. Okay, I'm going to pass it off to Nancy. Thank you.
Well, good evening to everyone, and thank you very much for joining us tonight. And I hope this session is helpful to everybody. I understand the plan is that we will go till around 7:30, and that often there is a break taken at some point, so people need to know that in advance. I just thought I'd mention that. So I'm going to jump right in and get started. The first topic is kind of some general things about preparing for hearings. If you're in court, you may hear some of this from the judge directly, but I hope what I'm going to provide you in this particular area covers most court appearances and gives you as much information as I can. So to begin, this is a slide of showing the layout of a typical courtroom. Most courtrooms look like this in Canada, regardless of the trial court level. So whether it's a provincial court or a Supreme Court level, they typically look pretty standard. You'll see at the front, the judge, and then the court clerk, witness box to one side. The parties, the long rectangles are meant to show a table for working areas, and then chairs. You'll notice that there's a row of chairs and then a straight line and then 3 rows of chairs behind it. That line is meant to reflect what we refer to as the bar. So when you're called to the bar as a lawyer, you can go ahead of that line, that bar. It's usually a fairly attractive wooden frame in the courtroom. But when you're attending as a party, you can go ahead of that bar as well. It may come as a surprise to some people to know that there's usually more than one matter that's in a courtroom on any given court day. So if you're coming to court, don't be surprised to see that it's in fact fairly busy and that there are more people in there. And there's usually a bit of back and forth at the start of the day to determine which case is going to proceed first, how much time it's going to take, what the relative priorities are. In terms of who will be present, there will be the other party on your case, usually. The parties involved in any other cases that are in front of the court. The court clerk or court clerks, and there's sometimes more than one because they have a lot of work to do. There is usually a sheriff in every family courtroom, the judge, of course. Members of the public may be there, lawyers, both lawyers who have cases in that courtroom or who may be there for other reasons or just because they're waiting for something else to happen in the courthouse. And it's a place where they tend to often wait to see what else is happening. And of course, persons involved in other cases that might not be parties. So for example, social workers, police officers, witnesses, those types of individuals. I would encourage people when they come to court to check in with the clerk as soon as you get there, once the courtroom's open, and it usually opens about half an hour before the session of the court starts. So if your court starts at 9:30, the room should probably be open by about 9 o'clock. Let the clerk know that you're there and that you're one of the parties on one of the cases, so the clerk can have a reference in case things are coming up to try to determine who is present or not, in case there is more than one matter before the court in particular. Next slide, please. I wanted to talk a little bit about court etiquette. It is, I'm sure most people will expect, there is a certain formality involved in the court process, and that relates to the need for citizens of a country like Canada to have this respect for the rule of law. And so there are these trappings that go along with courts and court processes that are meant to kind of underscore that. And there are formal rules that we all try to adhere to because they're important in terms of making the process continue to work. But we do try to make the process accessible to self-litigants, of course. I encourage people, if you're in the courtroom in advance, to look at the lawyer, if there's a lawyer acting for the party on the other side of your dispute, to try to get a sense of what they might be doing, because that may give you some pointers in terms of the process. You should feel free to ask court staff if you have questions about the process. They won't be able to answer questions about, legal matters, but if you have a question, say, when you walk into the courtroom, whether your case will be heard at 9:30, whether there are other cases in the courtroom, who else has checked in on your file, the court staff will be able to assist you in that. Both the sheriff and the clerk try to be as helpful as possible. And one last thing in terms of court etiquette, in terms of how to address members of the court. In our court, all of our judges are called judge. So if you're speaking to, if you're in court for a trial, you can just say, Judge Phillips. You can call us Your Honor is the other generic language that we use. We do have other judicial officers in our court. We have judicial justice of the peace. They do traffic and bylaw matters. So if you're at the family law seminar tonight, you may not encounter them. We do have judicial case managers, and I'll say more about those folks in a moment. They're senior scheduling officers of our court, and they are also justice of the peace that are usually called Your Worship, but you can also call them, case manager. If you're in the Supreme Court, the Supreme Court judges are generally called justice. So if I was a Supreme Court judge, you would call me Justice Phillips rather than Judge Phillips. It's a pretty minor difference in our province in terms of trying to remember the distinction. And in terms of calling the court clerks, generally they would not provide their names to you. So you can just call them, Madam Clerk, Mr. Clerk, or just court clerk. And I've just made a note in terms of, how you address them, that we're not too hung up on formalities in that sense, but there are various roles and you should just be alive to that. Next slide, please. In terms of what to wear, business casual is always safe, as long as your attire is reasonably, clean, not tattered, doesn't have any gang affiliation, is modest. Probably all of those things are acceptable. Generally speaking, I think today most courts are okay as long as you kind of fit within those parameters. I've added the word in my slide here, comfortable, because if you're present for a long court day, you want to feel comfortable. You want to not feel like your clothing is so formal or informal that it's becoming either uncomfortable to wear or a distraction to the process. So just turn your mind to that to make sure that that's not an issue for you. The next slide, please. I wanted to speak briefly before I get to accommodations on who you can bring to court. Our courts generally are in Canada open courts. And so that means that people can wander into the courtroom while it's in session, regardless of who they are. So we have people that will come to court because they like watching court, and they're welcome to do that. We have student groups that come through the courthouse. We have people who may have an interest in the proceeding but aren't actually a party or a witness. For example, in motor vehicle accident insurance cases, we may have insurance agents that aren't involved as a witness or a party who will observe if the matter involves, say, a dispute involving child protection issues. It's possible that a social worker or a social worker manager will be involved, and the courtroom is open. That may create some, stress for some people, but I do want you to be aware that generally speaking, an open courtroom is the starting point. It is unusual to have a courtroom closed, and I'll speak more about that in a moment. If you have witnesses who've come to be with you for the purpose of that court appearance, if you're at a trial, we ask witnesses to wait outside the courtroom until they're paged to enter and give their testimony, and that's so that they can't hear the testimony of the earlier witnesses or parties, so there's no suggestion down the road that they've tailored their evidence in light of what other witnesses have said. And generally speaking, at the start of a trial, the court will make an order, the judge will make an order, that what we call a witness exclusion order. So people who are going to be called to testify, if they're inside the courtroom at that point in time, will just be asked to step outside. In this modern era, we usually invite the parties or their lawyers to have cell phone numbers to text message those people when it gets close to when they'll be testifying, so they don't necessarily have to just stand outside the door. They can go away, get a coffee perhaps, or even farther away, and feel that they can be contacted as they get closer to the point where they may be called to testify. Support persons can be present with you in the courtroom, and I'm going to come back to that a little bit more later. There are, I perhaps call them two types of support persons: a support person more formally, and that's what I'll speak about later. But you may also have family and friends with you. It is an open courtroom, as I said, so those are people you're welcome to bring along. There's usually no issue with friends who are there to provide, emotional support for a family litigant being present. The only issue that you should give consideration to if you're going to have a family member present is whether that has the potential to cause some distress to the overall proceeding. You don't necessarily want to bring somebody who the party on the opposite side of you will react to emotionally, if that would cause what could otherwise be a fairly, civil, pleasant process to erupt without really much of a benefit from that. So I would just encourage you to think about that. I've certainly seen cases where a family member who perhaps has some animosity to the other side shows up to provide support. They're not there for some improper purpose, but it's misconstrued, and it can create some strain that can take a little bit of time in the court to just try to settle down. In terms of where to sit, as I mentioned, there is this formal bar in the courtroom where only the parties and lawyers can come in front of it and approach the tables where parties and their lawyers sit at the front of the courtroom. So you can't have your friends and family come forward of that bar. You can have an official support person do that. In terms of where you should sit, generally, but not always, the applicant party will sit on the left-hand side, which is the right side of the judge, and the responding party on a family file will sit on the other side, that is the right-hand side as you walk into the courtroom. But not many people, I think, at this day and age are necessarily too concerned about that. There's more of a history in criminal court about who sat on which side, but I would just encourage you to ask the clerk when you get in there, which side should I sit on? And the clerk will be happy just to help you out in that sense. Let me turn to accommodations, because I think this is something that a lot of people are not aware of when they start a proceeding in family court. In our family court in British Columbia, interpreter assistance is provided to the parties without charge. However, if you are at the start of your court case, so it's your very first court appearance, you may need to figure out a way to alert the court process to the fact that you would benefit from having an interpreter before the court appearance actually happens. There's no real magic in terms of how you do that. What I would suggest is you either email or phone the court registry to let them know that English is a second language and you would like to have an interpreter available from the start of the first appearance. And if the judge thinks that obviously that's necessary at all future appearances, the judge at the end of the first appearance and any subsequent appearance will make a direction that the interpreter be provided for all future appearances. It might be a different person, but that interpretation order will carry forward. In civil court, the parties are required to pay for their own interpreter, and often the party who loses the case, if the interpreter was required for the winning side, may have to pay the cost. That's not the case in family court. So if you were to be, if you hear of somebody saying, well, I had to pay for the interpreter, that's not the case in family proceedings, but there is a different rule of thumb that applies for civil court proceedings that you should be aware of. You can also ask the court to have somebody present to provide interpretation aid that's not a qualified or certified court interpreter. Some of the appearances we're going to talk about this evening are sometimes referred to as less formal appearances. They're perhaps pre-trial appearances, settlement conferences in particular we're going to talk about, where having a family member or a friend present to assist you with second language challenges is generally welcome, as long as that person has absolutely nothing to do with the case or the other party, ideally, but is there just to provide assistance to you if you should need it. A lot of people have fairly good English language skills, but perhaps on some more technical things may want the benefit of a second person just to hear the discussion and be able to just lean over and say, can you help me? I don't quite understand what that last comment was. And that is often quite a good workaround. But again, because you don't have to pay for interpreter assistance in family court, it's not necessarily something that you want to use when you know that formal assistance can be provided. But sometimes people don't want that. So I just mentioned that at a trial, that type of informal assistance will not be permitted by the court. We will need a formal interpreter because it's sworn evidence at that point in time. I also wanted to mention acoustic assistance. We have some pretty neat technology available in our courtrooms to assist persons who have hearing impairments to improve the audio in the courtroom for them. Courtroom audio can be challenging at times. They're huge, wide open rooms. If you're in a busy courtroom, people are coming and going and they're talking, albeit fairly quietly, but there can be a lot of background noise. The HVAC system may be running as well. So if you do have a hearing challenge, you should feel free, again, to let the court clerk know. It does take a bit of time to get that organized and set up, so the more notice you can provide, the better the court will be able to accommodate that. There are limited devices. They don't go to each courtroom. We have a number of devices in each building, and we need to set them up and move them around, but you should feel free to ask for that. And it's been my experience when people have a hard time hearing the evidence in a courtroom, and we take a moment and the court staff get one of those modules and actually set them up, that the difference, the improvement is really quite striking. So I'll just leave that with you to consider. Next slide, please. So carrying on with preparing for hearings, public versus private hearings. As I mentioned, it is very rare to have a private hearing in a courtroom. If you do have a serious concern about the court being open during your family hearing, you should raise that with the judge early on to see if that issue can be addressed about who is in the courtroom while your case is being dealt with. It may be that matters that are very private or personal, perhaps the case involves concerns about domestic violence or abuse. Perhaps there are documents that are going to be referred to, or photographs that are highly sensitive or private in nature. And you can raise that with the judge and see what can be done to address it. Perhaps, say, for example, there are photographs. The judge may simply make an order based upon the submissions of yourself and the other party that nobody be permitted to look at those exhibits once they get filed. Perhaps if you're testifying, though, at some length about something that's highly private, the judge could, upon submissions being made, make an order that the courtroom be closed for that part of the hearing. Or if that type of evidence is going to be led on and off throughout the entirety of the hearing, to give consideration to the courtroom being closed. So, as I said, this would be an unusual process, but there is an ability to raise that with the judge as you get started. I mentioned that there are a lot of people often in courtrooms at the start of the day. Having said that, by the time, 9:45 rolls around and everything's been sorted out, it generally turns out that most family trial courts are actually quite quiet once the trial gets started. And often it is just the parties, maybe their lawyers, and any witnesses and the court staff that are around. It's actually left to that fairly quickly in the day once things get sorted out. So rest assured, if you're showing up and it looks busy, it generally doesn't stay busy for very long as other matters get dealt with and find homes somewhere else in the building or resolved in some fashion. Conferences, about which we're going to talk more in a moment, are mostly done virtually by video now, and there's a sign-in process with email invitations for the links. Because of all of that, they've effectively become private, although they were somewhat private in the past. So that's not a concern. What I'm really talking about here are trial courts. I should mention as well that the content of the actual family file, so each court registry is responsible for either a hard copy or a digital copy of our family files. That's controlled by a fairly detailed court policy, and in family court cases is generally limited in terms of access to just the parties and their lawyers and nobody else, subject to them obtaining a court order. So that should address the concern in terms of who can access your court file material. And that would include such things as getting access to the exhibits or ordering a copy of a transcript or looking at what decisions or court orders are on the court file. Next slide, please. I would encourage you, regardless what type of court appearance you have, to take some time before you go to court to write out a point form list of things you need to raise with the court. You can also ask the judge once you're in court whether you can refer to those notes just to try to keep everything on track for your own benefit. It may be that the judge says, I don't want you to just stand up and read from your notes, but to be able to refer to it from time to time. If a judge does that, it's often because the judge may be concerned about how much time it will take to read your notes to the court, or a concern that they may contain either inadmissible or irrelevant material from a legal perspective and not want to inadvertently open the door to some inadmissible statement being made. So again, I would encourage you to make some notes, but just kind of be prepared to have to, maybe depart from them a little bit if the judge says, I'm not going to let you speak to that issue. It's not something that the court can consider. Don't take it as an offense. It's just meant to keep the matter moving along. Next slide, please. Who goes first? Generally, the family applicant. So whoever filed the application is going to go first. So if you've got an originating family application, say for seeking a parenting time order for the first time, there's no prior orders. If that's your application, you can be pretty confident that your side of the case is going to go first. So you'll testify and your witnesses will testify, and then the other side will testify and their witnesses will testify. Judges do have some discretion to have that done a little bit differently, and maybe that the first party goes and then the second party testifies and then their additional witnesses follow them. There can be some reason for that. It may be easier for people to give their evidence without blurring it by having their additional witnesses testify. So just be aware that there could be a bit of a departure from that, but that's the general rule. What I would tell people in family cases can last over time for a fairly long period of time. And it may be that even years down the road, there's a change. Say, for example, the original family case was all about a newborn child, and the child starts going to school, and there's another application to deal with issues relating to the changes involving the fact that the child's no longer home all day. And that may be the other parent that starts the court process again. And so then it's a question of who goes first with a new application. For the most part, not much is going to turn on that, but just be mindful of the fact that it may change over time, because that may help you address any concerns in that regard. So those were really the high-level overview stuff that I wanted to tell you to start. And now we're going to go into some bite-sized pieces, what I refer to as non-trial appearances, or sometimes you'll hear the reference pre-trial appearances, but pre-trial conferences are sometimes a technical term. So let me just generally refer to these as other than trial appearances, starting with the family management conferences. Family management conferences are actually a fairly new creation. They came in with our new rules a few years ago. They replaced something that I think most people found a little bit chaotic and perhaps a bit stressful, where everybody on a new family court file came to court on a single day, once a week, and it was very busy, up to, over 50 people in a courtroom. What we've done now is we have family management conferences on every new file anywhere in British Columbia, and these are scheduled by video, and we have just the parties and or their lawyers and the judge present by video for about 45 minutes. And I think it's probably a much more productive and less stressful process. How you get one of those is when you start a court file, a family file, by completing and filing an application about a family law matter, and the other person has filed a reply. That will then kind of cross a tripwire that will cause the registry to send you instructions about how to set up a family management conference. If you don't hear from the registry and you know the other side's filed a reply because they've given you a copy of it, it's certainly open to you to contact the courthouse, either the registry or the judicial case manager, to get the ball rolling. Generally speaking, these appearances are done by our judicial case manager rather than the court registry, and it's done by an email directed to them. It varies by court location as to whether there is a brief appearance for that purpose, generally by video for a scheduling, or it's done by email. I don't think much turns on it, just to be aware, because it's the first court appearance. It's not like there's a court order and the judge says, okay, here's your next court appearance. So it takes a slightly different tact in terms of how to get the ball rolling. There is another thing I should tell you about family management conferences. We also require people who have a new application to participate in a family management conference. So say the file has been dormant for a couple of years, but one party wants to bring up a new issue and files a new application. There is a requirement then for a request for scheduling form. a form that can be used to reactivate a family case, which has been dormant, and then that would be the tripwire to get a family management conference going. I won't spend any more time on that piece because I don't think it'll impact people much, but let me tell you a little bit more about the actual family management conference. So next slide, please. I'm sorry, I'm behind one more. Thanks, Rachel. Good, thank you. So a family management conference is a hearing with you, the other party, the judge, and your lawyer if you have one, or duty counsel in many instances, and the court clerk. As I mentioned, there is a support person. This is not just somebody who's there to provide you, general support, but this is actually somebody who fulfills a bit more of a technical role. So a support person may be allowed to attend a family management conference with you with the permission of the judge, and usually only where the other party agrees. So this support person would be there to provide you with, it's emotional support, it's just support to get through the whole process. Because when we have conferences, we generally discourage and don't allow other people to attend other than the parties, their lawyers, if they have one, and the court staff. We don't generally encourage support persons to attend, but we do see them there. So if you have somebody there who you want to fulfill that more official support person capacity, when you get to the conference, you should immediately bring that to the clerk's attention. Say, I have a support person with me. I would like to ask the judge whether that's permissible for the person to be with me. Usually, but not always, the other party doesn't take issue with that because it keeps things kind of calm, but you do need to raise that with them. And if you are not allowed, after the judge has considered your request, to have that support person attend with you, you should feel free to ask the judge to have that person wait nearby so that if you need the opportunity to seek their guidance or support during a brief break, you can do that. And I've seen people ask, perhaps on a family file that they want a support person present. It's not allowed, but the judge does allow the person to step out of the room and just wait, and then takes a break and allows the person to consult and chat with that person before perhaps consent orders are made. So that I just mentioned that, and I'll say more about the involvement of a support person for other steps in the process later on. You can ask for interpreter assistance for this appearance like any other appearance, but because it's the first appearance, you should make sure you've somehow gotten a hold of the court registry to flag that in advance. They are conducted remotely. There are very few exceptions to that. You should always make sure you have your most recent email on file because that's the way we get a hold of people now. And bear in mind, these appearances, although we try to get a lot done, they are only for 30 to 45 minutes. And so the judge may take a real active role in it to try to make the best use of court time, and not to cut people off, but because we're really trying to move the matter along. I would just say for all video appearances, not just for a family management conference, it's a good idea to have a neutral background for your computer camera, and also to do a test run for the technology if you haven't used it before. I've seen cases where a person has, problems with Microsoft Teams, which is the software our court uses. They might be quite good with other video operating systems, perhaps Zoom video, but MS Teams, for whatever reason, is incompatible with the device they've got, and they haven't had a chance or didn't think to check beforehand. And it creates all kinds of strain. It can cause a loss of time for your family management hearing, and we run out of time before the next matter has to get started. So always a good idea to test it. I believe when the court sends you the link, there's information about how you can conduct a test, and also they encourage you to do that. And also ask you to just be mindful of trying to have a quiet setting for the event, one that you can feel comfortable in and you can concentrate with. Next slide, please. Generally, family management conferences are a bit less formal than a trial, but because judges can make orders at this process or at this stage, even without consent, it is more formal than some video conference appearances. So the point generally of a family management conference is to try to settle any parenting issues, support, child and spousal support, or any other family law issues without the court going to a full-blown trial. It's a really important meeting, and I can't underscore the need for you to just take it as seriously as you can, because it may really assist you in resolving a lot of what's in dispute with the case. And as I mentioned, the judge can make orders. Judge can make both interim and some more rare final orders that could have a big impact on your life and the life of your children. And it can be hard to get them changed once they've been made. So it's an important appearance. The types of orders the court can make, just to be a little bit more specific, we can make orders about parenting responsibilities. For example, who has the right to make decisions regarding which school a child could attend. The court can make decisions about parenting time, about contact if the person is not guardian, but still has a parental relationship with the child. Orders can be made about both child and spousal support. And the court can also make many case management orders to try to help the parties move the case along. There may be an order, for example, for financial disclosure. The parties may be referred by consent or otherwise to go to alternative dispute resolution, such as mediation. There may be discussions about how documents are to be served on each other going forward. And the court can also make conduct orders, perhaps regarding how parents talk about the case in front of their children, or conduct orders about how the two adults interact. You should think about what orders you want before you get to the family management conference. And if child or spousal support are issues that you're wanting to pursue or being sought, and you're the party that could wind up paying, think about what your financial means are and what you might want to suggest would be an appropriate payment, bearing in mind there are child support tables and spousal support tables that give some parameters, but be prepared in advance to deal with that. It will make it much less stressful when you're there. Next slide, please. I'm sorry, one more slide after that. Can tell you that at the family management conference, judges try very hard to read all the current documents that have already been filed. That may include the court pleadings, brief affidavits that the parties have filed that support what is being sought by them. And the judge can also use all of the previous filed documents that are on the court file, although if it's a large family file, the judge may not have had the opportunity to look at that. So see, for example, you've filed material prior to the family management conference and a number of months have gone by before you get to the family management conference. If you have other evidence that you think might be useful to bring the court up to date, you can email it to the registry with a request that it be provided to the judge before the conference. And that can be such things as, photographs, additional financial disclosure, lots of other things. And the judge can use that evidence in determining whether or not to make an order. And if you're asking for several orders to be made, you may even want to send the judge or the registry a list of the proposed orders. For example, if you have a very complicated suggestion for holiday parenting time, it may be helpful to jot a few things down and send it to the judge before, because that may help you work through that discussion in the context of the hearing. I should tell you that handing documents to the court while the hearing itself is underway, that 45-minute hearing, isn't much of an option because the hearings are all virtual. So if that hasn't been provided in advance, it might not be feasible to look at it. If it's a simple, if somebody wants to refer to a text message and it's, a few sentences long, usually the workaround is for the judge just to say, can you just read it to me and to the other side? But if it's much longer than that, if you haven't provided in advance, it might be a bit of a challenge to deal with that. If your parenting plan or other issues are, extensive or complicated, as I said, do try to write that out. And if you can, provide it in advance. But if you can't provide it in advance, I think you'll find it's less stressful if you've taken the time to write it down beforehand and have a schedule you can work from. I see parents with or without lawyers sometimes providing the court with a draft calendar of what they're proposing for parenting time, either ahead of time, or if it's an in-person court session, to actually handing up the court a printout of a calendar, and that can be really helpful. The court will sometimes stand down, we'll get a photocopy made and give it to the other side, and we'll start working through that. So those are the types of practical things that you can do. I would just ask you to bear in mind that judges have many family management conferences scheduled per day, up to 6 or even more each day. So there's very little time to read the court file the night before, after you finish the last day's worth of court in advance. And so if you need to refer to additional material, I can't underscore how important it is to get that to the registry ahead of time. Otherwise, it's really unlikely the judge will have seen it before the start of the family management conference. And once the conference is underway, it simply may not be feasible because of the time pressure to review any additional material, and certainly not anything of any length. What you should know, despite all of that, is it is possible to ask for other follow-up family management conferences. And often, if the court feels that the parties have made even a little bit of forward momentum resolving some disputes, say, for example, at the end of the first family management conference, the court was able to work with the parties and come up with an interim parenting order. Maybe we didn't get the child support resolved. Maybe there wasn't enough time, or there wasn't an agreement, but there was enough forward momentum. The judge may suggest or simply order that rather than a next step being something like a contested hearing or trial, that we meet again for another family management conference, because it's usually better than getting into a contested hearing where animosity can be a challenge. And if there's an appetite for further collaboration, it's usually well worth pursuing. Next slide, please. You may have already heard in the earlier sessions you've attended through this education program with Amici that there are family duty counsel or family duty counsel lawyers available to assist you in most large court locations, or virtually in other locations. There are legal aid clinics, legal advocates, a lot of services out there to assist you. That can be really valuable at the start of an appearance, at the start of a court case, just as valuable as it can be at the end when you get to a contested trial, if you ever get there. So I would encourage you to see if you can get some advice from family duty counsel at Robson Square, one of our bigger court locations here in Vancouver. We have family duty counsel available when we have busy family courts, and you can call the court registry, find out when family duty counsel is available. They're generally very busy those days, but you can at least say hi, get their contact information, introduce yourself, and they will direct you to their office. So you can make a virtual appointment, at which point in time you'll have the privacy and luxury of time to go over your material, and they can access the file. They're an exception to the privacy of those files so that they can give you some information. It's also a situation where sometimes family duty counsel will actually appear at the family management conference with you. I can't speak to their policy on that, but you could certainly ask them to do that. And if it's a matter that would qualify, or your situation qualifies, they may actually be in a position to accompany you to the family management conference virtually and assist you in that process. I should say, if you're not able to reach an agreement of any sort during the family management conference, and the case does go to a hearing or a trial later on, I would hope that you still find that family management conference helpful to you in terms of trying to clarify what the issues are and what the other side's position is, because that will really help you, I think, to understand what might be involved as the case moves forward. So be prepared. It's like a mini application. It can be very beneficial, and it'll give you an idea about next steps. The other thing I should mention, just as I said, you could ask for a second family management conference, or a judge may order that. You can also ask for an adjournment, because there may be other things that you want to do short of trial. So just be open to being somewhat creative, although the judge will generally take the lead on that. And on to the next topic then, family settlement conferences. Thank you. So family settlement conferences are less common than a family management conference. Family management conferences are required on every case, whereas a family settlement conference is only ordered when a judge at a family management conference decides that this case would be good for a settlement conference. We call them management conferences because we're trying to manage the family dispute. We call them settlement conferences because we're trying to settle the case. We're always trying to settle cases, but the focus really at the family settlement conference is very much on settlement. And so if a judge directs that your appearance after a family management conference is a settlement conference, the judge has likely made an assessment that it's possible that the two parties can find their way to agree on some issues short of going to trial. And regardless, all of these appearances, I think you'll find help you plan and prepare for trial. Next slide, please. Because the family settlement conferences are very much they feel more like a mediation session with a judge. It may be that if there's a violence in the relationship, it may not be appropriate to hold a family settlement conference. The judge at the family management conference may appreciate that and not have in mind that a family settlement conference would be appropriate. But if you're in a situation where perhaps counsel is asking for a family management conference, family settlement conference on the other side, counsel for the other side is asking that, you may wish to say to the judge, given the history of domestic violence, I'm not, I don't think a family settlement conference would be appropriate. It's ultimately up to the judge to do that, but our general practice is not to order those where there has been concerns with family violence. Now, we do these by video, whereas we used to do them in person in a boardroom with a sheriff. So it may be that the concern as to the family violence past is less of an issue for some people, but it's really case specific. So I don't think I can say any more, but just to be aware of it. Next slide, please. So family settlement conferences, because we use them on far fewer files, we generally give them about 15 minutes longer than family management conferences to allow a more fulsome discussion about the case. They are less formal than other appearances. They're historically held in a boardroom rather than a courtroom at the courthouse. Judges didn't wear their robes. Sometimes we just wore, business attire. The family judge at that hearing, at the settlement conference, can only make orders, substantive orders, where both parties agree to it. So everybody's working really hard in the settlement conference to try to mediate some or all of the issues in dispute. And the only persons in the room then are the judge, the clerk, you, the other party, and lawyers if you have them. A support person, again, may be allowed to attend a settlement conference with the judge's permission and if the other party agrees generally. And if the court doesn't make that order, again, you can ask the person to sit outside so that you can consult with them if need be. At a family settlement conference, the judge will probably be quite interactive or engaged with the parties, talking about the issues that you can and can't agree upon. These might include parenting arrangements, such as where the children will live, who will make decisions about the children. So, for example, again, school, medical care. Can also include, although the focus is not on financial issues, but it can include child and spousal support, moving, parenting schedules, those types of things. And the judge will try very hard to help the parties come up with orders, interim or final, by consent. The family settlement conference is very much confidential, which means that neither party can repeat what the other person said at the conference to a trial judge later on. And this is to help people feel free to speak very candidly at the settlement conference to try to resolve the dispute. Next slide, please. I'm sorry, one more slide. Thank you, Rachel. Our Family Law Act in British Columbia says that the best interest of the children is the only thing the court is to take into consideration. So it's really clear that's always where the focus is going to be. And I would just ask you, regardless of the court appearance, but at the settlement conference, it may be easiest to think about it. If there are children involved, do try in advance to think about what decisions would be in their best interest as objectively as you can, because that's the only thing the judge can take into consideration. We'll sometimes hear parties say, well, that's not fair to me, or I have a right to something. But at the end of the day, the judge makes decisions based only on what's in the children's best interest. So try in advance to think of solutions that will be in the children's best interest and that also works for each parent. If you can reach an agreement on even some of the issues at the settlement conference and the judge can make a consent order about them, then you won't have to keep dealing with them as the case goes forward if it doesn't get resolved in its entirety. Next slide, please. At the end of the settlement conference, if you can agree on any issues, the judge will make a consent order and that will end the matter. That will be put in writing and you'll get a copy of it. It's akin to a court order, and the record will become part of the court file and has the same effect as a court order. Next slide, please. I would encourage you, again, specifically for the settlement conference, but always as the case proceeds, if you're unable to resolve the dispute by consent, the family story, let me just rephrase that. I said this is for any step. This is specific to the family settlement conference. So if you're unable to resolve the dispute by consent and you reach the end of the family settlement conference, the judge may, but not always, offer their opinion on what, in their experience as a family court judge, the likely outcome of the trial will be. This opinion is not written down or disclosed to anybody else, including the judge who will hear the trial. If the judge at your settlement conference does get to the point where you hear the judge saying, I'm going to tell you what I think might happen if this case were to get to trial on this issue or that issue or overall, it may be a really strong indication of what the likely outcome of the trial will be. It's not necessarily the outcome because it's very different, a settlement conference from a trial, but it may be helpful to both parties to more realistically assess the strength of their position in the dispute and make them more open to trying to resolve it other than through a trial. So you can ask the judge also for their opinion as to what might happen in terms of an outcome of the trial, and the judge may be willing to offer an opinion. For example, if the judge hears each parent talk about what they would like to see happen in terms of which school they think their child should be attending, the judge may, after an hour-long settlement conference, have a pretty good sense of which proposal is in the child's best interest and may say, you know, if I was hearing this as a trial judge, I think this person's proposal is most likely to be in the child's best interest for these reasons. Say, for example, there's less travel time. Siblings are at the school. It gives them access to some athletic programs that the child has an interest in. Their friends are there. Those may be the types of things that the judge says, look, I don't know for sure what a trial judge will do, and I'm not going to be the trial judge, but here's what I think is likely going to happen. So if you hear the judge saying that, take it very much to heart. And if you want to ask the judge whether they're prepared to offer an indication of what they think might happen at trial, you can do that as well at the settlement conference. I would just say to you at the end of the settlement conference, if you know you're thinking, I don't like how this is unfolding, I want to go to trial, keep in mind that at every trial, there's almost always going to be somebody who'll feel they've won and the other person will not. And it's not necessarily predictable because that's why we hold trials. They are not a predictable event. We don't know for sure what's going to happen. At a family settlement conference or any type of mediation or alternative dispute resolution in family court, it's always possible for both parents to feel they've reached a fair resolution. It may not be perfect, but it's one that they're in control of and that they can agree with, rather than a stranger to the family, which a judge is in all instances, had to craft because there's been no other option other than at a trial. So I would encourage you to take these pre-trial opportunities to resolve cases very seriously, because they can really give you an element of control that a trial doesn't really afford people. Next slide, please. So if you don't resolve issues at the family settlement conference or other information is required to resolve any of the disputes, the judge will likely schedule a trial, and usually, although not 100% of the time, another judge is going to conduct the trial. The family settlement conference judge will usually try to spend just the last few minutes of the settlement conference trying to figure out what, if anything, can be cleaned up before trial, trying to figure out what information might be able to reduce the amount of time the trial will take. and the judge will ask the parties questions to try to get at those things. Usually this is just done with the last few minutes left. For example, who's going to testify, what kind of documents they might be relying upon, will interpreters be required, will experts be involved, trying to get a sense of how much court time the trial will take. And I can tell you that estimating court time is very difficult. It's an art, it's not a science. Lawyers struggle with it, judges struggle with it, but we try our best to make as accurate a time estimate as possible. So when you ultimately do come to the trial, we've got it as close as we can so that you don't have to keep coming back if we can avoid it. The judge may conclude the settlement conference by making orders that will help you get organized and prepared for trial. That can be orders about exchanging copies of documents such as financial statements, perhaps text messages, photographs, those types of things. And you can ask the judge questions about how to present your evidence at trial, and time permitting and the judge being willing, will try to provide some direction and perhaps offer or refer you to other sources that will help answer your questions. I should also tell you that if a case is scheduled for trial at the end of the family management conference, be mindful of the fact the trial date can be many, many months away. And in the interim, you'll have a chance to access other legal assistance if you want. All kinds of other services are available, some of which you may have already heard in earlier sessions of this education forum. For example, Legal Aid BC, the BC Government Court Information website, the Provincial Court website has a lot of information on getting ready for court proceedings. The BC Courthouse Library, Click Law, which is a digital service created by the Courthouse Library in BC, has lots of information as well. But there's all kinds of things available for you. Keep in mind, if you're doing your own type of research online, you want to be sure that you're dealing with British Columbia family law information, because it does vary from province to province, and provincial court rather than Supreme Court family law in this province. You can also ask at any point to be referred back to a family justice counselor in the hopes of trying to resolve some or all of the issues. So you may not be able to get another settlement conference with a judge, but you might want to pursue that. There are also free or low barrier, low cost mediation services available in many, many communities throughout our province. I'm just noting the time. Rachel, would this be the right time to take a break then for everyone?
Yeah, we can certainly take a like 5-minute break, or do you want more? 10 minutes?
5 works for me, I'm sure.
Perfect.
Everybody will want the break. Thank you very
Yeah,
much. So I'll just
amazing.
turn my camera off and go on mute and be ready to go again in 5 minutes.
Amazing.
Thank you.
So we'll start again for everybody at 6:35. So I will pause the recording as well. Thank you.
Thank you.
Okay, perfect. We're back from our break. So I will pass it back over to Nancy so she can keep on with the presentation tonight. Thank you, everybody. Oh, Nancy, it looks like you're muted still. Sorry.
There, I think that's fixed. I just had a slight audio problem. Can you hear me all right?
Yes, we can hear you.
Good. Thank you. Forgive me for that. Just 1 second. Good. Next slide, please.
Okay, perfect. Do you want one more?
No, that's good.
Okay, perfect.
Oh,
Great.
I'm sorry. Yes, one more. Thank
One
you.
more. Okay.
To trial preparation conferences. That's perfect. Thank you. And I don't see my image, but can everybody still see me all right, Rachel?
Yeah, I can see you.
Good. I must have a bit of a technical bug here, but please let me know if that changes. So the next step, I'll keep my comments fairly short about trial preparation conferences, only because very few cases go to a trial preparation conference, but mostly just to make you aware of this step in case you have one scheduled for your court case. We ask parties where the court case is going to take a little bit of time, so usually something more than half a day or a day to attend a trial preparation conference. If you have a lawyer, that person will attend and you don't have to attend as long as your lawyer is able to reach you to get instructions. It generally is a short court appearance with a judge to discuss how the trial will proceed and what, if any, steps are outstanding to get the case ready for trial. There's no specific time frame for when these get scheduled, but they're typically held about 4 to 6 weeks ahead of a scheduled trial, usually far enough in advance if there are some things that need to get done to get the case fully ready for trial, that there's a little bit of time left for that to happen. You should be aware that if you do have to go to a trial preparation conference, if a court's ordered it, there is a requirement under our family rules. Rule 110 requires that each party must prepare and serve a trial readiness statement no later than 7 days prior to the trial preparation conference. And there's an actual form 22, to fill out for that purpose. There isn't a specific rule as to what the parties need to bring to a trial preparation conference. But there are some things that I can suggest that you may find of assistance. And Rachel, I think I'm at the next slide, sorry. Thank you. So you may want to prepare a summary of the issues and your position about each issue. It's always a good idea to do that for every court appearance, but as you get closer to trial, that becomes more important. And be aware of evidence that you intend to use at trial, including the documents that you might want to rely upon, including experts' reports, if any, and the witnesses, the names and contact information you intend to call at trial, and have a good estimate for how much time they're going to take and what their evidence will be in a general sense. The judge at that trial preparation conference may also make directions about the time, date, procedure, etc., about how evidence is to be received by the trial court, including how a child's views can or should be received, expert witnesses, an exchange of documents, and any other direction that the judge may give to try to expedite and keep the trial on track. The judge may make orders or directions about what additional witnesses can be called, requiring parties to give the other side a brief statement about what each witness is going to say, what we sometimes call as a will say statement. And anything along those lines to expedite the trial or to assist the trial process. And again, as I've said other times, you should also use that trial preparation conference as one last opportunity to see if the case can be resolved or focused or narrowed other than going through a trial. So turning next then to the trial process. Next slide, please. One after that. Sorry, one more. Thank you. Let me just begin my comments about trials by letting you know that very few cases ever go to trial. If you watch, American court television, you'd think every case goes to trial. The fact is very, very few cases go to trial. The lowest number of cases is in criminal. The next lowest is in civil and family. So most matters do get resolved in some fashion without a trial being held. And it's really important to keep this in mind as you proceed through the court process. There are many, many more cases in our court system than there is ever going to be available court time. So judges play a role in helping litigants resolve cases without having a trial, and in making sure trial time is only assigned where other means to resolve a dispute have not been successful. There's an added incentive in family court. If you get into a civil court dispute, perhaps there's a dispute with your bank, when you're done, whoever wins or loses never has to see or deal with the other party again. You go find another bank, but win or lose in a family court case, the parties still have to have contact. And because of that, and because the trial process historically has been an adversarial one, it often can make things difficult for the family to try to move forward after there's been a contested trial. So it's an added reason why courts try with the parties and with their lawyers to find a way to resolve disputes other than going through a trial. And it's also important to bear in mind that even if there is a trial, that may not end the matter, because as children grow and as parents' lives change, new issues might come up that require a return to court. So it's important to keep that in mind. Say, for example, you've got a 3-year-old. You shouldn't necessarily be thinking of an order that's going to be the thing that takes care of everything until the child is independent and grown and on their own, but rather perhaps to think about, okay, what is this going to look like for me and my now separated partner or spouse to get to the point where the child's about to start, say, grade 1 or kindergarten, because it's a full day now. because that may help you be much more practically driven on what type of order you could live with, knowing it's not going to be final. And if you can work it out that time, you may be able to work it out again when the child starts kindergarten. You might come back to court and again come up with a mediated agreement or through an alternative dispute resolution. So family cases are very different because of that. We realize people may need to come back, but we also at the same time try to not make it any more adversarial than has to be, recognizing that that relationship is never going to ultimately come to an end. So let me get into a little bit more nuts and bolts about trials, and then we'll wrap up for the night. So next slide, please. I'm sorry, one more. Thank you. I've called this a binder, but you can think of it as a file folder, an e-file, however you like to organize your self. I would suggest that you will keep your stress level down if on the day you start your court case, file your first document in court or send your first letter to the other side suggesting some type of resolution, that you start keeping a file of all of that material, because some of it may be needed later on. And if you've got a file going or a binder going, it'll just be so much easier when you have to pull all that material together and be prepared to come to court to present that evidence. You might want to use a written outline of your case as an organizational tool. Regardless of the method, it's more a sense of kind of coming up with what you think the issues are and what you've got as evidence starts to accumulate, and put that binder together. You may want to give yourself a bit of a to-do list for dates by which you need to take specific court steps. Again, this may help you keep things on track and keep your stress level down. You should be thinking about saving copies of documents, and in particular electronic materials such as text messages that might be needed for court later on, so they don't get deleted by an automatic system in an app that you might have used. And also, please to be sure to save the complete message thread, not just portions of conversations or messages that may prove your side of the case, because an incomplete message thread is often given very little weight in court if it's not clear what a response is if the question's unknown. You should also start thinking fairly early on about putting together a list of witnesses that you may be calling at trial, their addresses and phone numbers, and maybe start putting together a real point form summary of the evidence you expect them to give to the court as the date of the trial approaches. And you should also start thinking about creating a list of documents that you intend to rely upon in trial. That will essentially be your index as you get close to trial, and a section with all the court documents in date order. This is a lot of work. I realize that, but the expectation of the court, whether you have a lawyer or not, is that you will come to court with documents that are indexed, that are organized, that have page numbers on them, multiple copies for all the parties. It is a lot of work, and I can see people at times when judges are explaining what they need to do to get ready for trial, they realize it's a lot of work. And we know that, but it's part of the reason why we work hard with parties trying to help them settle disputes, because it can be a fairly daunting amount of work involved. So once you've collected all of that material that you intend to try to use at trial, you should then start to be thinking about, okay, so how do I prove this evidence, or how do I put this evidence in at the trial? Say, for example, let me try to give you a concrete example that may assist you. Say, for example, there's a disagreement about what dental care a child might need, and you want a court to give you the final decision-making authority for any medical treatment. And you want to be able to refer the judge to a bunch of emails between you and your ex-spouse about the discussion and the dispute on dental treatment. But nobody's thought about, well, what was it that the dentist actually told me the child required, and how am I going to get that in front of the court? So you need to be thinking about that piece. Did the dentist just tell you verbally that your child has cavities that need care, and this is how much it's going to cost? And if so, can you get a hold of the dentist and get something in writing? Was it something more serious? Say, for example, the dentist thought there was some neglect going on and you're suggesting the other party doesn't provide that dental care. You need to be thinking about what kind of evidence you can provide to the court to prove that position. Next slide, please. And you do need to disclose that material to the other side. Before I just move on to this, what's up on the slide screen, I should tell you that again, unlike television court dramas, we don't allow people to produce material during the trial for the first time. In other words, trial by ambush is not allowed. If you've not disclosed material to the other party well in advance of the trial, and there are some rules about that, it's unlikely a trial judge will allow you to use it, or they may give it less weight because of the fact it's not been disclosed in a way that allowed the other party time to respond to it. Or it may be such that the judge is left to not really know what to make of it because the full picture hasn't been provided. So it'll be much easier if you disclose the material ahead of time. Otherwise, you could be faced with a problem once the trial rolls around and it hasn't been disclosed. In terms of the witnesses to call for the trial, I sometimes say to people that trials are not a numbers game. The person with 10 witnesses doesn't win when the other side only called 8 witnesses. So you should really just be thinking about, what can I tell the court and what am I not able to tell the court that I want the judge to hear about, that's going to help the judge make the decision about what's in the best interest of my child. It may be that there's another caregiver that knows the family situation that you think can give evidence on your behalf. That may be a family member. It may be a caregiver that's not a family member. It may be somebody who's a professional, perhaps a daycare worker, perhaps a teacher. You want to be thinking about those people and try to limit it to just the people that you think can add something meaningfully that will assist the court in coming up with its decision at the end of the trial. And if that person will not agree voluntarily to come to court, or if you're uncertain if they'll show up, then you need to think in advance about getting a subpoena to require them to testify and perhaps bring any documents that they will need to look at for the trial. And there are specific provisions about having subpoenas issued, and you can talk to the court registry. Those staff there will be happy to assist you with that. You do have to give potential witnesses, when they're subpoenaed, some expense money to cover their travel to the courts. If it's in a big city and they live somewhere in the city, that may not be much, but if you need a witness to travel from out of town and they're going to be testifying and having to stay overnight, you can start to look at some considerable expense involved, and you want to just try to weigh that out. Some people require subpoenas, even if they are cooperative, because perhaps their employer doesn't allow them to miss work by way of a subpoena. And you may also want to think about whether the person can give their evidence by using video. So if you have a professional witness who says, I can give evidence, but I'm teaching that day, and if I could do this over my break and just do it from a video location in my school, it would be much easier. So you need to be thinking about that, and you may need to apply to the judge for permission and get an order for that to occur. With or without the other side's agreement, that's something you're going to have to address, and then get some equipment set up for that purpose. As you get closer to the case, or to the trial, you need to do a bit more work with the witnesses. And I think we're on to my next slide now, Rachel. Thank you. You should prepare a list of the issues that you're anticipating you want them to speak about. Make a list of questions to ask them, and review those questions in advance with the witness before trial. You'll make your life easier and the witness's life easier if you do that in advance. You might want to start with basic questions such as their name and occupation, and then their education if relevant, how they know the parties, what their relationship is, and then move on to the focused area of inquiry. For example, if it's a question about one parent supposedly having been under the influence of alcohol or drug when they're exercising parenting time, you may want to ask them how often they've seen that parent with the child, and what, if anything, they've observed about whether they've ever seen anything suggesting the influence of alcohol or drug. So get right to the point then. You can only ask your own witnesses, so the witnesses that you've called, what we call open-ended questions, meaning that the answer to the question is not suggested by the question itself. Questions that direct a person to an answer, kind of like a yes or no, that's very limited, are ones that we only allow witnesses to be used with witnesses in cross-examination. In other words, of the other party's witnesses. So bear that in mind. If it's your witness, do try to ask open-ended questions. It often carries more weight as well as the other reason, rather than suggesting to a person the answer. Asking them a more open-ended questions is often more helpful. I just want to tell you very briefly about expert witnesses. And Rachel, I don't think I have a slide on this one. Forgive me, I've kind of just wanted to mention this. It's not that common in family court to call an expert witness. We see it more often in civil court, where perhaps you see a motor vehicle accident reconstruction expert, or in criminal court, perhaps you got a firearms expert. But we do see them occasionally in family court. Perhaps somebody will be testifying about a child's special needs. Perhaps the child has autism, and the parenting issues touch upon autism and special needs of the child. So you may need to be thinking about having an expert testify. There are some very detailed provisions that relate to when a person is giving expert testimony versus not giving expert testimony, and what qualifies as expert testimony, and the witness themselves has to be qualified as an expert. I won't go into that because it probably is too much detail, but just be mindful of, if you get to the point where you or the other side is looking at calling expert evidence, just to become more familiar with what's required of you. If it's your expert, generally speaking, you have to produce an expert's report to the other side, and that has to be done in a certain time frame. Generally, it's no less than 60 days before the expert is to give evidence in the hearing, that you would have to provide the other side their opinion evidence in writing, and a written summary of the expert's evidence. There are some things that flow from that. And again, I'm just trying to summarize a whole bunch of information here. Say, for example, the other side sends you a notice more than 60 days prior to your trial date that they're intending to call an expert. You're also then entitled, and you'll be asked, generally speaking, whether you want to have that expert come to court to testify, so that you can ask the expert questions in cross-examination. There's a time requirement that you let the other side know that, and that's 30 days before the trial. So the party who wants to call the expert has to give you 60 days notice, no less, of the expert's report in writing, and then you would have to respond no less than 30 days before the trial if you require the witness to come to court so you can ask them questions in cross-examination. Oftentimes, the party doesn't want to do that. They're simply prepared to accept the opposing party's expert's report, because experts are supposed to be objective. And if you read the report and you think, you know, I don't necessarily agree or disagree with this, but I don't think I'm going to gain anything by cross-examining the person, it seems like it's logical, there's a foundation for it, you may simply let the other side know, you can just file that report. I'm not going to want to ask that person questions. It may be very difficult to ask questions in cross-examination too, if the person's expertise is particularly, you know, detailed and extensive. It can be very challenging to ask that type of witness questions in cross-examination. Even for a lawyer, it can be quite difficult. So I'll just leave that with you. Forgive me, just let me have a sip of water here. The next slide, please. So just a few more kind of nuts and bolts things about a typical trial. You'll be given a chance, each party, to make an opening statement. I like to refer to this sometimes to help self-litigants as a roadmap about what you think the case will look like at trial. For example, you might want to say to the judge, I'm going to testify, and I'm calling the child's daycare worker and social worker. And we will be asking the court to make an order that I should have all the parenting responsibilities, and that the two of us will share parenting time with the child. So it doesn't have to be overly detailed, but just a bit of a heads up for the judge of what they can expect. In terms of who goes first, I go back to my comments earlier tonight that generally the party whose application is filed, not the party who's responded to the application, will go first. Judges do have some discretion as to which witness will, or witnesses will go first after the first party has testified. Generally speaking, trials involve the witness's testimony from the witness stand and any documents that are provided. That can be, text messages, photographs, emails, paperwork, all those types of things. As documents get admitted into evidence, as long as they're admissible, they'll generally get some type of exhibit number assigned to them. The clerk will stamp the actual court copy of the exhibit. You should mark your own exhibit. I'd encourage you to do that. So if the judge says this series of text messages will become exhibit number 5 on the trial, take a red pen, mark your copy of it as exhibit 5 in case you need to refer to it from time to time. Or if you're cross-examining a witness, you can ask the court clerk, could you please give the witness a copy of exhibit number 5? These are the text messages that were referred to earlier. And then witness, can you please turn to this text message at page so-and-so, and I want to ask you a question about it. It'll just be so much easier for you if you just take a moment to do that. And you shouldn't hesitate to ask the judge just to have a moment to do those types of things, because the pauses that we take to allow the parties to stay on top of things as the trial unfolds usually pays off. So generally speaking, a judge will say, yes, take a moment, make a note, let's all keep organized, because this is going to go much more smoothly if we do that. As I said earlier, to frame open-ended questions for your witness, close-ended questions for cross-examination. Lawyers will tell you generally you shouldn't ask a witness a question in cross-examination when you don't know what the answer is, because it may not be helpful to you. Sometimes the temptation is too great or the advantage is too great. That can't be resisted. In terms of cross-examination, it's not something we do at all in our ordinary lives. So judges may provide a bit more direction in the context of a trial as to what cross-examination should be like. Judges may not, depending on their practice and the nature of the case. I would just encourage you to think about, what is it you're trying to get from the witness in cross-examination? Was there something that they haven't spoken about yet that you think could assist your side of the case that you should then ask them about, because they may not have been asked about it by the other side because it didn't help them? You may want to use cross-examination to challenge the person's memory, which is reliability. Perhaps they gave really good evidence, but you know that they don't have much of a memory, or they didn't make any notes. So you think, well, how could you remember the details of what happened at the New Year's party 5 years ago? You didn't make any notes of it. So you may want to suggest that it's unlikely that they would remember it. So they may be trying to be truthful, but just not be able to remember. You can also challenge a person in cross-examination by asking them questions that will get to their credibility. How truthful were they actually trying to be with the court, and to challenge them on that. I wanted to say just a few more brief things then. Oftentimes in family court, I shouldn't say oftentimes, but sometimes in family court, a party will ask to play video or audio evidence of the other party interacting with a child, not necessarily with a child, but it's often with a child, where the other party wasn't aware at the time that a recording was being made. I suppose it's no surprise, because most of us carry cell phones that have got audio and video recording capabilities these days, and you can quickly turn them on and do that. But generally speaking, it's not appropriate to audio or videotape somebody without their consent. And if you come to court and try to rely upon that evidence, judges generally discourage that. We don't want that, because it creates all kinds of strife in the family. And it's often the case that it's not particularly helpful evidence. There may be an audio or video clip of perhaps an exchange where the two parents are involved with the child going from one home to another, and there's some unflattering things said in the video or audio that the person wants the court to listen to, but the court doesn't know what the lead up was. Perhaps there was a screaming match that's not recorded or depicted in the video, and we're asked to see a clip of it without having that other footage running, and then you can get into a lot of court time trying to determine what happened beforehand. So generally speaking, filming without consent, video or audio, is to be discouraged. You may not find it that a judge allows it to be admitted. It can be on occasion, but even where it is, it may not be given much weight in terms of how much their judge relies upon it in coming to their decision. One other thing, if you are going to challenge, excuse me, if you're going to say in your own testimony something that's quite different about what the other party has said in their testimony, there's a rule called Brown and Dunn, but I'm going to recall it the rule of trial fairness. You need to give the other party a chance to speak about it. Let me give you an example that has nothing to do with a family case because I think it's easier. If it's a car accident case and somebody says, this is how the accident happened, and then the other party, the other driver gets on the witness stand later on in the trial and says, it didn't happen that way, and I know it didn't, Your Honor, because it was snowing and I slid and I took photographs of the slide or the skid marks in the snow, and here's the photograph. Well, if the other person's already testified and no questions were asked of that other party about the fact it was snowing or that the car skidded badly, then the judge doesn't know whether that witness would agree with it or not, disagree with it, or what to make of it. So if you're going to put a suggestion, if you're going to say something quite different, it is best, it's preferable as a matter of fairness to give the other party a chance to respond to it. So just be thinking about that. It may not come up in many cases, but it can be very significant when it does. And then finally, with respect to closing submissions, just like I said, you can give an opening statement. The judge will be giving you a chance to make closing statements. It's your chance to think about what was the evidence that the judge heard that really helps my side of the case, and say to the judge, you know, you heard this evidence. Just at a very high level, I suggest you can rely upon this evidence to get to the outcome that I'm asking you to get to in my favor, and summarize what orders you're asking for. Two last things, and then we're on to the Q&A. Personal preparation. I would encourage you to visit the courthouse that you're going to have your trial at, or any type of appearance at a conference for that matter, to familiarize yourself with it unless you know it already, including checking the hours of operation, parking, where the court lists are posted, if they're digital or if there's paper copies, where the washrooms are, maybe where some break rooms are where you can go and have a quiet moment, if there's food in the complex or it's near the courthouse, if you don't plan on packing a lunch. All those things can help keep your stress level down. You can also consider watching a trial. Courts, as I said, are open. Trials are open to the public, and generally they're in session from 9:30 to 12:30, and again from 2 to 4 or 4:30 each day. And also to keep in mind to engage in self-care, as with a trial for any type of stressful event, ensuring you get enough sleep, you're eating healthy, getting some exercise, and that you have the emotional support you need help with to get through the process. And lastly, you probably are aware that costs, and I think I'm on to my last slide, thank you, can be awarded when a winning party, to a winning party in cases. But generally speaking, you should be aware that costs are not payable in provincial court. And in particular, they're not payable generally in family provincial court, and each party is responsible for their legal fees and their out-of-pocket expenses. There are some limited exceptions to that in our family court rules. There can be penalties that can be imposed for non-disclosure, or fines for non-disclosure or non-compliance with court orders. And there is one other exception to that, that if a party requires an expert to attend for cross-examination, or a views of the child report writer to attend to testify, if the judge determines that the family justice counselor who wrote the views of the child report or the expert's attendance was not necessary in order to resolve the case at trial, the judge can order the party who required that witness's attendance to pay the reasonable costs of that person coming to court. So there are a couple of things that catch people by surprise sometimes that I simply wanted to make you aware of. And that brings me to the end of my comments. So Rachel, let me pause then and over to you. Thank you.
Perfect. Thank you, Nancy. Okay, so we have now's the time for questions. So if anybody would like to submit their questions, feel free to put them into the chat now. I'm going to read out some of the questions and address what I can. And if there's anything that we need to get Nancy to weigh in on, we will get her say. So um actually this first one will probably be a question for you, Nancy. Um, how do the courts feel about children in the courtroom, specifically where a parent isn't able to get childcare? Yeah.
Sorry, again, my microphone went on mute of its
Oh,
own
good.
accord. My apologies for that, folks. Yeah, the question about children in the courtroom, I can't speak for other judges and I can only go on my experience, but in my experience, um, I break it into two things, children that are old enough to understand what's going on in the courtroom, even a little bit versus newborns and toddlers. We recognize for family court proceedings other than other than at a trial, we have fewer of them now because so much is done remotely. But for family court proceedings where people actually have to physically come to the courtroom for a short trial, excuse me, a short appearance, and there are daycare pressures, childcare pressures, we all recognize that. Usually people would just accommodate that and not much is said. I've been in many courtrooms where a young child is in the courtroom. Often the parent will say, sorry, Your Honor, I did have, sitter plan, something, that person got sick. I had to bring my child to the courtroom. Usually everybody just goes, that's fine. Let's just carry on. We're not going to worry about it. Even if the child's fussing a little bit, we work around it. We all recognize that happens from time to time. But the older children, we generally don't want them coming to family court. There are just too many sensitive issues that are too hard for young children to understand. And with respect to older children, I think that it's a slightly different concern, and that would be that they could be at risk of getting drawn into the dispute if the parent's case is before the court that day, even if it's inadvertent. So I think that's probably all I can say about that. We don't encourage children to come to court. We certainly don't encourage them to be called as witnesses to testify. There are other ways to try to get their input when required or appropriate. So I hope that's of assistance then.
Yes, thank you. So I think I can answer this one in regards to what is like for a Mackenzie friend. And in my understanding is that as a support person or Mackenzie friend, they would need the approval of the judge to be able to be there with the person. So they usually could be there as like support to help with taking notes or just emotional support, but they do require the court to approve of their attendance with the party.
Yes, that's all accurate. And
Perfect.
the more likely, excuse me, at a trial, that's more likely to be approved. So the person would be able to assist the person keeping them organized, perhaps having a quiet word or two, maybe making notes for them, all those types of things. Yes.
Perfect. Okay. Um, in terms of the family management conference, there's no limit to how many family management conferences they can have, right? Yeah, okay. So
Correct.
I
Yeah.
believe that you can have as many as you need in order to work on your matter. And then family settlement conferences are less common.
Yeah, we used to have family settlement conferences on most family files, but now that we've added the step of family management conferences, they're less common. But people, I don't think, should hesitate. If there's any forward progress between the parties trying to work out issues, I think most of the time you'll find you're, going to be well received if you're asking the judge, can we have one more family management conference? Can we have one more settlement conference? Most of us know that headway is to be pursued.
Okay. Um, okay, so the next one is arbitration regarded as a trial. So I believe that's an alternative dispute resolution or ADR, right? I think that arbitration is not actually considered a trial.
Yeah, I'd
Okay,
agree.
yeah, perfect. Okay, sorry, just reading through some of the
Sure.
questions. Okay, so there's a question about what a written submission is. So usually a written submission is something that outlines like a party's position. It's submitted to the court as their argument and reasons for their cases. Um, and then their question is, do the judges read those? And I guess the answer would be yes, right?
Yeah, they're really important documents. So yes.
Perfect. Another question, why are some cases sealed? So cases will be sealed for protecting privacy, prevent harm, or preserving the integrity of a case. Public cannot access a sealed case, and in most family cases, those are sealed. And
Yeah.
both provincial and supreme.
Yeah, I wouldn't say most family cases are sealed, but most family cases are not accessible by
Mm,
members of the public. You can walk in and anybody can access a criminal or civil case with very few exceptions. You can't walk into a court registry and get access to a family file unless you're that party or the lawyer,
okay.
or you have a
And
court order. Yeah.
yeah, okay, yeah. So to further on that one, the question is if it is sealed, can transcripts still be ordered or reasons for judgment? But like if you are the party for that case, then you can obtain your transcripts, you can obtain your reasons for judgment.
Generally, I would agree with that. Yes.
Okay. Okay. Thank you. Okay, this one's interesting. What is a deposition versus a discovery? And are they both necessary before trial?
Yeah, that's a very interesting question. We don't have either in our court. It's a provincial court. We have neither depositions or discovery. I think deposition, and this is just off the top of my head, is actually more of an American concept. We have discoveries
Yeah.
generally in British Columbia, but those are in Superior Court. It's not a process that's available in provincial, family, or civil.
Okay. Um, in what circumstances would a trial be done online? Do we have that in the provincial court?
Yeah, that's a really interesting question. During the pandemic, we
Mm,
did do some family trials online out of necessity. I don't know that we've done any family trial online in its entirety since the pandemic restrictions came to an entire end. I think going forward, as we continue to expand our use of technology in all facets of our life, it could happen in perhaps the longer the case, probably the less likely it would be. But if, say, for example, it was simply a dispute about whether a person was entitled to spousal support, and it was only scheduled for, say, 2 or 3 hours, if a party, was looking at traveling and the other party didn't have any issue on it, perhaps the parties would want to ask the court to allow that to occur by video. It would be up to the judge. It would be individually case driven. So yeah, I suspect that's where we may be going on that. But right now, it's very much. I think not the entire case will be done by video, and it always requires an application if it's a witness.
okay. So let's see here. So I guess to clarify the interpreter assistance, in provincial court, it's provided by the courts, right? Whereas in Supreme, that's a different matter. Usually the parties have to get their own interpreters in Supreme Court, unfortunately.
Yeah, I don't know the answer to
Yeah.
that.
Yeah. So one of the questions, yes, in provincial court, interpreter assistance for trial is provided by the provincial courts. And we don't do Supreme in this session, but that would be a separate matter for, and if you do have your question about Supreme, you can send us an email about that and we can address that in a different point. But yes, so you can send an email if you have any questions about that. And then in provincial court, court costs are not dealt with. So there is a question about court costs here as well, but that one is going to be just dealt with in the Supreme Court for
Yeah,
family
with those
matters.
couple exceptions that I had. Yes, exactly.
Yes, yeah. Um, so I believe you touched on this as well. The previous affidavits that somebody might have from one of their previous hearings, would that typically be read by a judge for context in a different application, or should evidence be kind of included in those specific affidavits?
Yeah, I would say that if it's an old affidavit, see, it was filed, months earlier for a separate stage in the court file, you should probably not assume that the judge would have read it in advance of the hearing, because these files can be very, very large, and we deal with so many over the course of each and every court day. It just wouldn't be possible to do all of that on every single file and have current knowledge of every affidavit. But the affidavit would remain on file, and if you want to refer to it, usually it's simple just to say to the judge, have you had a chance to look at this affidavit? If the judge says no, you could say, I wonder if I could just ask the court to, pull out that affidavit from the file, take a look at, paragraph 20 on page 4. And there may be something that's fairly straightforward that you can just highlight, so it doesn't require the judge actually taking, 20 minutes to read the whole affidavit. The point that you've got is fairly narrow. But if affidavits are filed for a current application, I think you can have a higher degree of confidence that the judge will have recently read them. Sometimes, again, time is just simply not available given the volume of materials that we have, but we do try on the current matters to have read that material.
Okay. Um, I know in the Supreme Court, so forgive me, I'm not as familiar with the provincial court myself, but is a party able to attend an appearance by a video conference if they live like out of province or out of country?
I'm not sure I know the answer off the top of my head
Hmm.
on that. I think the party could apply for a case management order seeking that, and then it would just be up to the judge to determine that. We
Okay,
do
yeah.
get video applications. The out of country one is one that will present some challenges because of our court hours and the time difference. But
Yeah.
I do think it seems to me that we probably have seen those. I just not if they're just so uncommon. I don't think I could speak to it.
Yeah. Okay. Yeah. So, if you do have other questions, again, for everybody that is tonight, if your question isn't addressed, if it's not about specific legal advice, you can send us an email and we'll try to address it if we don't get to it tonight. Um, do- yes, to clarify, there is no cost for provincial court trials, including the interpreter assistance, in the provincial court. So that's different in the Supreme Court, but yes, that's no cost in the provincial. Um, okay, I think that's majority. Oh, there's a question about requesting an extension to be able to find a lawyer. Um, and I'm not entirely sure if that's like at the court or the other party, but in most cases, if somebody's trying to find a lawyer, an extension would be reasonable, so long as there's not an unreasonable delay.
Yeah, I think that's probably very common
Yeah.
in family and civil court, that somebody needs some time to get a lawyer. They haven't been able to find one, they haven't been able to afford one, or the lawyer that they had is no longer their current lawyer and they need more time to get another lawyer. Yeah, so if you're in that situation, you should get a hold of our judicial case managers so that we know in advance, because it may be that, say, for example, it's scheduled for a family management conference. It I'm not saying that the judge would necessarily grant an adjournment to allow a person to get a lawyer, but generally speaking, that's not an unreasonable request. So it just helps us with scheduling. If it's a trial and you show up on the morning of a trial and say, I want time to get a lawyer, that's a different situation. And you may find it unlikely that a judge will let you do that because it will have been months and months and months in the system. And probably judges early on will say, you know, are you going to be acting on your own behalf? If not, if you're going to get a lawyer, you need to get on it. So the longer it goes, the less likely, but yeah, we do want to give people that opportunity generally.
Okay, there is a number of Supreme Court questions, so we aren't able to answer those ones. So I'll just kind of skip over some of those. We have a few more minutes left if there's some questions about the provincial court in terms of what we've gone through tonight. Let's see if there's any other questions that come in. Okay, I don't see anything coming in immediately. I'll give it another minute here, but we just want to thank you, Nancy, for coming in and speaking with us tonight. Yeah, on behalf of myself and as well as some of the other participants tonight, we really appreciated everything that you have told us tonight. Lots of insightful information. So, yeah, no further questions. So I think I'll end the session here tonight. Yeah, just let us know if there's any questions to our email. And everybody, I hope you all have a good night, and we'll see you next week for week 8.
Thank you very much, everyone. Have a good night.
Thank you.